So my name is Sigal Chattah. I'm the candidate for Nevada Attorney General. Unfortunately, I'm the only candidate here today, but fortunately for you guys could ask me all the questions that you want. I'm running for the Attorney General's office because I think that the current Attorney General has failed in various issues. The first one being transparency, the second one being the top police officer and law enforcement officer, as well as the top prosecutor. Never has Nevada been unsafe as it is today. And additionally, we all know what happened during COVID and the fact that he allowed the governor and other administrative agencies and other government agencies to violate Nevada's Constitution. So.
All right. With that being said, panel questions. Go ahead, Frank.
How you doing, ma'am? Thank you for coming out. So as the AG, we have right now a corrupt sitting judge who is sitting on, I believe, the Supreme Court, who, when he was a prosecutor, withheld evidence that would have kept an innocent man out of prison for 20 years, who was 800 miles away from Nevada when a murder was committed that he was charged for. He had that proof, chose not to use it, and he's now a sitting judge. What would you do about that type of corruption?
I'm just talking about the Fred Steese case, correct? Am I allowed to? I'm sorry. Did I violate already rule number one?
No, that's the case I'm talking about. Yep.
So let's talk about the Fred Steese case for a second. First and foremost, you know that the body that is relegated with engaging in what to do with a sitting judge is the Commission on Judicial Discipline. Okay. If the Commission on Judicial Discipline has not done anything, whether it's an issue of statute of limitations or not, and I'm assuming that you are talking about Judge Herndon and allegations of prosecutorial misconduct that occurred, correct? Mm-hmm. Okay. So allegations of prosecutorial misconduct are adjudicated by the state bar. This is something that the state bar is very clear on. We have Supreme Court rules that all prosecutors have to abide by, whether they are federal prosecutors or state prosecutors. These are issues that are outside the realm of the Attorney General's office at this time. Okay, so I would have to defer to those two bodies, okay, whether it's the Commission on Judicial Discipline, when he is a sitting judge, okay, and the State Bar of Nevada, which is the proper arbiter that would handle any issues with prosecutorial misconduct.
Next question.
Good afternoon. So, in this state, the insurers cannot be sued under workers' compensation for employees. You have an exclusive remedy, and you have to go through the Division of Industrial Relations. And we have sent more than a couple of complaints, and I'm talking about local attorneys, because the insurers are basically, in my opinion, committing fraud. They're refusing to pay legitimate claims. And in one case, the third-party administrator, the insurer, went to a doctor and had the doctor change his opinion and lower his rating on an employee, and we had proof of that, and sent it to the Attorney General, and he did nothing. So we have sent complaints of insurance fraud because that's criminal. So now you can't use the exclusive remedy. And I'm just asking you, if you became the Attorney General, would you be willing to look at how the insurers handle the claims, and if it's fraud by definition, which a lot of it is, would you pursue that?
Absolutely, I would pursue that.
Could you tell me about the Repair the Vote PAC litigation with Richard Scotti, please?
Okay.
I heard a little bit about it earlier. I just wanted to fully understand where you guys are coming from.
So Repair the Vote PAC is a PAC that was established to repeal portions of AB 321 that was passed in the last legislative session. There's two ballot initiatives that have been put forth. As many of you know, you need 40,000 votes from each congressional district, so a total of $160,000 votes to have this on ballot. Okay. So one of the issues that, like I said, we're dealing with repealing 3 sections of AB 321, and the second one is for voter ID. So that's the litigation is litigation to challenge those ballot initiatives. And without getting into too much detail, because we are still working out those kinks.
Understood.
As a matter of fact, I do have a brief due next week. Without getting into too many details on that, that is essentially what the litigation is about. The litigation has been brought by an attorney named Mark Elias. Many of you might know from Perkins Coie, formerly Perkins Coie, and he is the attorney that represented Hillary Clinton and did a lot of the litigation on behalf of Hillary Clinton.
Thank you.
Would you support and launch an investigation into October 1 and the GoFundMe account and where that money went?
The question was about October 1 and...
You know, yours isn't working either.
Check.
Okay, I got the question. Whether I would launch an investigation into October 1. As long as the statute of limitations is not up on that investigation, which I would have to review, I would absolutely launch an investigation.
Next. Robert, go ahead.
Can you talk about the lawsuits? There's Asian students who've sued universities over discrimination that Aaron Ford is supporting. Can you talk about that litigation, what you would have done or would do if elected?
Sure. The lawsuit that you're referring to is Students for Fair Admissions versus Harvard. It's known as SFFA v. Harvard. That is a lawsuit that was brought by a group of Asian students regarding admissions policies in Harvard. The lawsuit was essentially based on the fact that Harvard was allocating points to other minorities and not taking into consideration the Students for Fair Admissions and the Asian students that were involved. Right now, it is up to be heard by the Supreme Court of the United States. And what would I have done differently? AG Ford had submitted an amicus brief, which I could assume that most of you guys know what amicus briefs are. It's kind of like a position brief in support of Harvard as a proponent for affirmative action and not based and against the meritorious admissions.
Nevada actually has the death penalty. We just tend to seem to not really use it, even though we spent, I don't know, millions of dollars on that new facility. It's all pretty and collecting dust. Recently, there was a case, I believe 2 years ago, where a young man stopped two people from fighting, and an elderly man decided to go in his house, grab a knife, and then stab that young man straight in the heart, killing him right then and there. Would you be for the death penalty in a situation like that where it's 100% guilty, people saw it, you're there, there's witnesses, there's the thing, you killed somebody that had nothing to do with what was going on?
I'm a proponent of the death penalty. I believe that all capital offenses should be met with capital punishment.
I want to follow up on that real quickly because our state has failed to actually carry out.
Hear you, Rob.
I'm sorry, because I wanted to follow up because our state has failed to carry out a death penalty execution for over a decade. We have people who've been on death row for 40 years and are going to die of old age. What would you do as Attorney General to push that process along?
Look, like I said, I mean, ultimately, we have a system where capital offenses, and we have a separate system to determine the sentencing and whether that individual will be sentenced with a death penalty. As a proponent of the death penalty, and like I said, I am a proponent of the death penalty, I do believe that capital offenses should be met with capital punishment. And without having any... I don't believe that the Attorney General's office could expedite an execution.
No, however, there's been litigation over the drugs used.
Correct, and that was, yeah.
Is that something you could litigate to, or adjudicate perhaps, to clear up?
Okay, so I don't have the power to adjudicate as Attorney General.
I'm sorry, litigate.
Okay, it is adjudication only comes from the arbiters, which are the judges. I could litigate on that, but as far as adjudication, that's something that is in the purview of whatever judge it is, and if on the Supreme Court decide. Yes. Okay.
So somebody else going, I'll go. Right now, certain businesses, while they're allowed to conduct themselves how they choose because they are private businesses, have no firearms beyond this point, certain areas. Would you be able to adjudicate, or as you said, something that says along the lines that if you made it to where a person could not defend their own life or the life of others by what you chose to do, you would then be liable for any catastrophic event that may have occurred where that person could have acted in self-defense and saved others?
Okay, I'm going to ask you to be a little bit more specific because that question, I think I understand the question.
Okay,
Are you asking me about whether I can do anything for, let's say, safe zones or school zones?
Not even just necessarily that. Like this business has a sign up front that says no firearms beyond this point. Should something catastrophic happen here, normally I would be carrying. I would be able to respond to that event and stop the threat. But since I have to follow their rules and they created it to where I could not respond, they should be liable for any damages perceived after that point because they created that situation.
Okay, so first and foremost, without getting into too much nuts and bolts on litigation on whether the property owner is on notice of a criminal offense, because that's really the standard that we look at. Let's say you go to any hotel or any business, you can't, there is not an automatic issue where you sue the hotel for a third-party criminal act. And, you know, I'm trying to really narrow it down as far as the way the law truthfully works, as opposed to, you know, speculation and conjecture and giving you an answer that's not even feasible. Okay. I think I am a constitutional carry proponent. I am a proponent that we should have constitutional carry in the state of Nevada. And like I said, I mean, the question that you're asking has so much involved that there's no yes or no answer.
Next question. Anybody? Go ahead.
I have a question. Since marijuana has been legalized on a state level, should convictions for the use or the possession be mitigated or shortened or granted for pardons?
Since marijuana has been legalized, should convictions for possession be mitigated?
Yes.
Okay, so there is as far as, you know, possession while operating a vehicle, just simple possession. I mean, there's, you know, I understand what you're saying, but the reality of it is there's not just a, you know, possession element. There's possession while driving a vehicle. That's illegal. Okay. There's, you know, possession while having a firearm. That's illegal. So just a simple possession is not really a question that could be addressed without having it either merged with another situation, because today, just a possession, you will not. We have recreational use in Nevada.
Absolutely, but there are people who have been convicted on that are serving sentences. And I was wondering, in regards to you as an attorney general, can you mitigate those sentences or even in your area?
As Attorney General, I think that I have an obligation to look at every incident as an isolated incident and apply the law objectively. Again, like I said, I mean, there's various issues with just a simple possession. Oh, I guess I'm not.
Could you?
Sorry.
You talked about the current Attorney General. Could you elaborate a little bit on maybe the what you disagree with the most of his current position?
Okay, so there's quite a few things that I disagree with the Attorney General.
I would agree. Pick your favorite.
First of all, one of the biggest issues that I have is the transparency and lack of enforcement of PRAs. I believe that when you do have a lack of transparency, and as an attorney general, he does have an obligation to provide the people of the state of Nevada with the transparency that they deserve. The issues come up when we're dealing with transparency that it leaves a lot of room for speculation and conjecture. Okay, when questions can be answered very simply. Okay. Another issue that I have with him is the way he's handling the Attorney General's office and the attrition that we saw. Remember, the Attorney General is the top cop of the state. We have never had an Attorney General that has been so hostile towards law enforcement and district attorneys as we have currently. And those are probably the two major issues. We can talk about the COVID cases and what I've litigated, but ultimately those cases are history, with the exception of two that are now being litigated. But those cases are history. That's not going to define where I stand as a candidate. My issues with the Attorney General's office are present and future issues.
Who's next here? Go ahead.
As Attorney General, what bill draft requests would you submit to legislator?
I'm sorry?
What bill draft requests would you submit to legislature?
The first bill draft request that I would submit is mandatory minimums on felons in possession of a firearm.
Okay.
I think as a proponent of the Second Amendment, this is something that is very near and dear to me, because I believe that we have a serious issue conflating gun owners' rights with the lack of prosecution of felons in possession.
Okay.
So that would be one of the top ones.
Thank you.
Over here.
The Arizona, after they did their 2020 forensic audit of the election, that Attorney General has really done nothing with a lot of that evidence and kind of slow walked all of that. He should have been prosecuting the many that they have discovered that committed fraud. If you were in that same position, what would you do?
So I will not comment on anything that AG Brnovich has or has not done, because I am not privy to the evidence that he has seen. Okay. As somebody that would be in that position, I would have to base an opinion and whether to prosecute or not on the evidence that was put in front of me. I can give you a hypothetical based on speculation and conjecture.
Okay, so some states have a law. It's called mutual combat, and it's at any given point, if two adults over the age of 18, regardless of the gap in the age or size or anything like that, agree to fight, no police are allowed to arrest, no charges are allowed to be filed, as long as they do not damage private property. If they damage private property, it's a separate charge. They tend to have a lot less overcrowding, a lot less issues with police having to deal with hostile people because the two people fight it out and then it's done. It's almost like being charged with a fray here, but actually there's no charge at all. Would you be opposed to anything like that, allowing two combatants to fight as long as no weapons are used?
I think there's an issue with that because of escalation. And again, I don't know that I could back that type of any type of legislation because of the fact that there are probably issues with escalation and what is force and what is not force and what is, agreement on force. I think you're speculating that when two individuals are combating, that there are rules of engagement that both will adhere to. I don't know that that would necessarily be realistic.
No, it would just be you're allowed to fight that person as long as no weapons are used. So if I leg kick him and breaks his leg, oh well, that's his fault for starting a fight or agreeing to a fight with me. I'm not allowed to be charged. He's not allowed to be charged. Cops are not allowed to be dispatched or, force used against us if we're using a mutual force against each other. Like, we have to agree, everybody has to hear it.
Do you understand the issues that come with such a legislation or such an allowance, right?
No.
Who's to say? What if one of them then says, "Well, I didn't agree to this, but I agreed only to this"?
No, it would be a blanketed mutual combat. That is it. End of story. It doesn't matter if the person has registered hands. It doesn't matter if they're an MMA fighter. If you agree to fight somebody, that's it. End of story. Whatever happens is on you.
You know, as an attorney, I got to tell you, there's so much that goes into that I don't know that I could adequately really give you a firm yes or no. Just because in my head I'm looking at all the liability issues and
Zero. It's between the two, and that's it.
Right. There's you know, when you have consenting adults engaging in purportedly consensual conduct, okay, I have more times than not seen someone turn into a non-consenting adult.
Follow up on the end. Go ahead.
I'd like to digress for a second to follow up on the felon in possession of a firearm, and I'm glad that it's near and dear to your heart, so to speak, because in my career I was a police officer for 25 years, so we literally put hundreds of felons in jail on a regular basis, and I can tell you that it was never taken seriously. And I know that goes to the DA, but you did mention a bill draft, right? And so the excuse that a lot of the detectives use is, well, it's also a federal charge, so we'll just send it to them, and so they have less work and things like that. Would you be willing to, on a bill draft, possibly consider having a state mandatory punishment?
That's what I was referring to.
Right.
Obviously, the federal government and the state government are separate sovereigns, and that is what I was referring to. I would like to see mandatory minimums on felons in possession of a firearm with the state. Yes.
Yeah, because very few do time on that.
And I'd like to see it run consecutively with the underlying charges as well.
That would be perfect, in my opinion.
Go ahead.
Thank you.
Robert?
What case is now pending before the federal court, Supreme Court, taken up by other attorney generals in the country, would you join? Texas cases, Florida cases, that kind of thing.
Voter ID, I believe, is still being litigated, and that is something that also, obviously, I'm representing Repair the Vote PAC. Voter ID is a very serious issue to me. It is something that is so fundamental in this country. I would probably join that. I also would probably join General Paxton's litigation on the Keystone pipeline. What we saw in Keystone, for those of you who don't know, is that there was a separation of powers issue. So a lot of these constitutional cases, because I'm a originalist as a constitutional proponent, I would probably join many of those.
I'm going to steal somebody else's idea that was brought up earlier, but as one of your BDRs, would you be interested in having a bill that added to the sentence of somebody who killed a police officer, so you made it an enhancement on that charge?
Absolutely.
Go ahead.
Possibly even consider that to be a hate crime.
Well, hate crimes, the enhancement on a police officer, and as far as hate crimes usually run on whether it's national identity, whether it's sexual preference, whether it's gender, and so on and so forth. I think having an enhancement for a law enforcement is a lot more feasible in one way, as opposed to specifically lumping it in with hate crimes.
Understood. What category would that fall under then? If not hate crime,
it would be an enhancement.
Okay,
There's a separate enhancement for hate crimes and a separate enhancement for law enforcement.
Understood. Thank you.
So,
Can I follow up real quick?
Go ahead.
On that same subject, I think what the problem was I think they brought it up in 2017, if I'm not mistaken, the enhancement. but enhancement for a police officer didn't do well politically, right? Because it would be his own enhancement. So you're literally creating an enhancement. However, if you go under the hate statute, and I think this is where it got some traction, is you're being killed because you're a police officer. Like, because you hate the uniform, you hate the badge, you're sitting in your car eating lunch, and they literally kill you because you're a police officer. But the aspect of an enhancement on its own didn't really get much traction. So I don't know how well that would do.
I think what we need to look at is requiring an enhancement based on a profession is different than an enhancement based on race, national origin, and so on and so forth. Agreed, right?
Well, they did try to throw the medical personnel in there, and so that got some traction, but what really got the traction more, I don't know why, but on the hate crime side, that it got more traction in the legislature, in my opinion.
You know, I think that when you look at where society is now and how there's a swing in the pendulum of the fact that, you know, when we saw police officers being killed solely because they are police officers or law enforcement, I think what you will see, God willing, in the next legislative session, you will see an ability to pass an enhancement for that type of, and a lot of it, again, it depends on the composition of the legislature.
Thank you.
Go ahead, Frank.
Nevada, we've noticed, since legalizing and decriminalizing marijuana, we've seen revenue go up. We've seen, cops actually go out there and handle other business, that's much more important than somebody smoking a doobie. Would you be okay with legalizing and regulating prostitution throughout all of Nevada?
I think those are completely different issues. The legalization of prostitution is done in the rural communities for a reason. Okay. I think what we see here, and especially with Las Vegas being the trafficking capital of, probably the country, definitely the state, I think what needs to be reviewed is the composition of trafficking versus voluntary use of prostitution or escorts. And that is something that has to be examined very deeply before.
Good afternoon, ma'am.
Hi.
Here in Nevada, especially here in Clark County, we're seeing a surge and increase in crime from 2020. And with that, Metro, with the arrest, are seeing a lot of repeat offenders that are coming through the system. And a lot of these repeat offenders have been let out on like minor cash bonds. And I wanted to see where you stand on this bail reform and how that's affecting the repeat offenders and also having them escalated up into a serious, assaults as well, including maybe homicides as well.
Okay.
Where you stand on that issue. Thank you.
So I'm an opponent of bail reform. I have always been an opponent of bail reform. I'm also quite a vocal opponent of initial arraignment court. I was an opponent of it back in 2016. I'm not a fan of the Valdez-Jimenez decision. I believe that you punish the crime and not the criminal. And anytime you give bail with disparity between two people that committed the same crime, you have an issue. Now, your question is actually three different questions. Let's talk about repeat offenders and habitual offenders, okay? Repeat offenders and habitual offenders need to be prosecuted under habitual offender statutes. I'm afraid that, unfortunately, and I do blame the top cop for this, because when you have an attorney general that acts more like a public defender, the message that sends out to county DAs is that, I'm not gonna be tough on crime. I don't expect you guys to be tough on crime, and that's an issue. So as the top prosecutor, I will prosecute and send a message that habitual offenders and repeat offenders need to be prosecuted to the maximum under habitual offender statutes.
couple more questions. Who's next? Go ahead.
Since you said you'd be the top prosecutor, as you kind of said it, would you go hard against people who do like home invasions? Because it's kind of not really a thing here in Nevada.
Robberies and burglaries?
They don't go hard on them. I know from personal experience having my home broken into, and I know from helping Metro, especially Bolden Area Command, they don't get sentences that they should get. They don't, and they're usually repeat offenders. Would it be something you kind of went forth to help families know that they're protected in their homes, and should their home ever be invaded, that they will be protected later from those people?
Yes, I will be very hawkish on crime. I think anybody who's spent more than 5 minutes with me understands that. The reality of it is, I think, like I said earlier, when you have a top cop that is soft on crime, it sends a message out. And it sends a message out to law enforcement. It sends a message out to prosecutors. Now, with that, though, I want to qualify that with saying that right now, there is a shortage of law enforcement. Now, whether this is a shortage that was caused from 2020, 2021, 2022, the idea that there might be a removal of qualified immunity for law enforcement, law enforcement morale, it's a tripartite system, right? You have to have the prosecution, you have to have the law enforcement, and you have to have the adjudication. One cannot function without the other. So,
anybody else? Okay.
Just a quick comment. We submitted many habitual offenders to the DA, many. And one gentleman had about 18 burglaries and never really did any time. And I can tell you that I cannot remember one that was ever prosecuted in all the time we've done it. They don't take it seriously.
I want to address that for a second. The Supreme Court of the United States just issued a decision 2 weeks ago, against actually in favor of the defendant, where the defendant had broken into 8 different homes in one night, and whether that defendant was to be seen as a habitual offender because he broke into 8 different homes in one night. The United States Supreme Court issued a decision that should have been treated as one incident. So as an attorney, whether I'm in private practice, whether I'm the Attorney General, I do have to operate under the auspices of what Supreme Court precedents are. Now, until there is adjudication, otherwise, then that would be the precedent that is set as far as that is concerned.
Well, I meant on different days, not all in one night.
Okay.
Anybody else? Okay. Go ahead.
You said the qualified immunity thing is kind of an issue. What about maybe putting something in place that the officers who are ever attacked or hurt during the commission of a crime, like trying to stop somebody, can then sue the families of the criminals too? Since the families can sue the department and the officer, why don't we turn that around? Same with victims of crime.
Understood. Now, again, that deals with negligence issues, and as a matter of fact, that's a workers' comp issue, because you are getting injured on the course of your job. Okay.
Okay, I see what you're saying.
Do you see what I'm saying? Mm-hmm. So if I'm a cop and I'm injured during the course and scope of my employment, that's a workers' comp issue. That being said, on qualified immunity, as you can possibly imagine, I am absolutely against removing qualified immunity for law enforcement.
All right, so at this time, I'll now give you the opportunity to make a final closing remark on why we should support you.
Thank you. First of all,